This is the second-part continuation of defense attorney Adam Allen's opening statement to the jury.
I'd like to discuss the concept of revenue versus profit. You will learn that revenue is the total amount of income generated by a company. In contrast, profits is the amount of income that remains after accounting for all of the company's expenses, debts, and operating costs. So, revenue is the total amount of money that's coming into the company, and profit is anything that's left over after the company covers its debts and obligations. A company can satisfy its debts and expenses and not be profitable. Two other terms that are going to come up during this trial is the concept of equity financing versus debt financing. You will learn that equity financing involves selling a portion of the company in exchange for working capital. In equity financing, the company shares its profits and losses with the individuals who are buying the equity in the company. Debt financing is also a method to raise capital, but under this scenario, the company is raising capital by borrowing money in the form of loans. And in that scenario, the company must repay the debt with interest, but the profits and losses are not shared with the lender. The profit and losses stay with the company. You will learn that Mr. DaCorta's companies use both equity financing and debt financing. The only concern for somebody who is loaning money as an investment opportunity is, will I get my money back? Will the person I'm loaning the money to repay me my principal and repay me my loan? In dealing with loans as an investment opportunity, there is going to be a loan agreement, and the loan agreement sets the terms for repayment. When do you have to repay the principal, how much interest you have to pay, and the money loaned typically earns interest. The agreement sets forth the terms for how the money is going to be used.
Here, Mr. Allen missed an opportunity to explain that there were two Oasis companies, and that both Oasis Management and Oasis International Group were initially funded through combined equity and debt financing. By August of 2017, all equity shareholders, except the three founders, had converted their equity interests into loans. Lenders had no share in the company's profits or losses thereafter. The lack of these critical clarifications will result in much damaging confusion later on. The government will use the confusion to continually misrepresent Oasis lenders as equity shareholders who were misled and deceived by Mr. DaCorta because he did not reveal corporate profits and losses to them. As lenders, they had no business knowing about them and suffered no losses from them. Oasis's only obligation to lenders was to repay their loans according to the terms of their promissory note and agreement, which was always done.
There was a point in the autumn of 2018 when all Oasis lenders were required to update their information on the new Oasis Internet site, which featured daily earning reports for each lender. By March 2019, if they had not signed the Oasis International Group's promissory note and agreement, their money was returned and their account closed.
In the lending investing, money is loaned to the borrower. The funds are used for the stated purpose, and the principal and interest is repaid. You will learn that the person borrowing the money has a legal obligation to comply with the terms of the loan. In this scenario where somebody is investing in a marketplace, the investor typically provides the money to what's called a fiduciary trader, somebody you are giving the money to. You are not trading the money yourself. You are giving the money to somebody else, and that person then trades or invests the money in the marketplace.
Lending investing is debt financing described before, but then Mr. Allen conflates debt and equity financing by following his statement about lending investing by saying, in this scenario where somebody is investing in the marketplace, that's an equity, not a debt investment. The scenario was about debt investing. His example is about equity investing. How could the jury not be confused by this?
It will be important for you to realize that the broker-dealer, the place where the trading takes place, also gets money on every single trade. You are going to hear that Mr. DaCorta's company owned a broker-dealer and was making money notwithstanding profit and losses on every single trade. You are also going to hear about corporate proprietary trading. So fiduciary trading is when a person or a company is taking on individual clients' money and trading it in a marketplace. Fiduciary corporate proprietary trading occurs when a company is simply trading its own money. It doesn't have individual clients. It's trading its own money. And when that happens, the company gets the profits. The company suffers the losses, and the company is trading its own money in one corporate trading account. The broker-dealer is getting a piece of the pie on every single transaction, whether the trade was successful or unsuccessful.
Fiduciary trading is distinctly different from proprietary trading. There is no such thing as fiduciary corporate proprietary trading. It's one or the other, but not both. What Mr. Allen is describing in this hopelessly convoluted and confusing statement is proprietary trading, not fiduciary.
Well, what were we talking about?
A fiduciary is a person or organization that makes financial decisions on behalf of another party and is legally obligated to act in their client's best interests. Proprietary trading refers to an institution using its own capital, rather than client funds, to conduct financial transactions.
Either the company is trading on behalf of its clients, and therefore has a fiduciary duty to them, or it's trading on its own corporate account, in which case it's responsible only to its principal owners and equity shareholders, if any. Mr. Allen made an extremely important clarification with the following.
It will be important for you to keep clear during this trial that fiduciary trading is not the same thing as corporate proprietary trading. Mr. DaCorta's company was not involved in fiduciary trading. He was not trading for individual clients. His company was trading the company money. With fiduciary trading, there's individual segregated accounts per customer. And with corporate propriety trading, there's one corporate trading account. The concern with fiduciary trading is for each individual client, and the concern for corporate trading is the corporation. Now, you're going to hear a lot in this trial about foreign exchange market, and it will often be referred to as Forex. Forex is simply the exchanging of one country's currency for another. Here in the United States, currency trading is regulated by the Commodity Futures Trading Commission. They're called the CFTC. You will also learn that in the United Kingdom, it's the Financial Conduct Authority that regulates the trading of currencies. The CFTC only regulates trading of currencies and commodities within the United States. There's different authorities that regulate commodities and currency trading all over the world.
This would have been a good time for Mr. Allen to mention that Oasis traded through ATC brokers in London, using Oasis-owned broker-dealers in Belize and New Zealand, but never through brokers in the United States. Doing this may have clarified his points to the jury, but he didn't provide that context.
You will learn that the individuals in the U.S. who are trading currencies in a fiduciary capacity have to be registered and regulated by the National Futures Association. If somebody is going to trade commodities, which includes currencies for somebody here in the United States, they need to be regulated and a member of the NFA.
This last statement is false. Only if a trader is trading as a fiduciary for other people, without benefit of an exemption allowed by the CFTC, do they have to be a member of the NFA and registered with the CFTC. Mike traded solely for Oasis's corporate accounts as a proprietary, non-fiduciary trader, which exempted him from the requirement to register.
Mr. Murray talked about this concept of spread, and you're going to hear a lot about spread in this case. Spread is simply the amount of money difference between the buy price and the sale price of two currencies.
Here again, it would have been helpful for the jury to know that in every Forex currency trade, there are two different currencies involved, called a pair, and the trader is always selling one and buying the other, or, in trader parlance, he's short one and long the other. The spread is the difference between the ask or sell price and the bid or buy price.
So here the sale price is $39.44 and the buy price is $37.25, and the amount of money difference between those two currencies is what's referred to as the spread.
In Mr. Allen's example, The spread would be $39.44, the ask price, minus $37.25, the bid price, or $2.19. But it's no example of a Forex spread because spreads are typically measured in 1/100%, which appears in the fourth decimal point 1 unit of which is called a pip. A more realistic Forex spread would result from figures like $39.4405 versus $39.4402, or 3 pips.
I like that last number.
What did you like about it?
It was the last number.
It was central to Mr. DaCorta's defense that the jurors understood that trading was done exclusively for the corporate accounts of both Oasis Management and Oasis International Group, and thus Mike was not required to register with the NFA or the CFTC. But this essential clarification was never made clear.
Mr. DaCorta's company purchased a broker-dealer, and a broker-dealer is the trading platform where currencies are traded. And every broker-dealer has the ability to earn transaction fees on every single trade and a portion of the spread for putting the buyer and the seller together.
Put more directly, every dealer earns a transaction fee or spread fee on every trade transacted on their platform. Consequently, every trade placed by Oasis through their own broker-dealer platform earned Oasis spread revenue, regardless of whether the trade itself resulted in a profit or loss to the shareholders.
The evidence will show that Mr. DaCorta's company had negotiated to be able to trade currencies at 1/100. And so what that means is, if they put $1 as collateral for trading, they were authorized to buy and sell currencies as if they had $100.
This statement is seriously misleading. Mr. DaCorta didn't have to negotiate to trade currencies at a 1/100 ratio. That is very commonly afforded by nearly every Forex broker to any trader. More to the point, Mr. DaCorta never traded anywhere near that dangerously high ratio. He knew that doing so was too risky.
You are going to learn that when Mr. DaCorta was acting as a fiduciary trader, when he was trader for individual clients either in the stock market or the commodities market, he was highly licensed and highly qualified. He is a Series 7 license. He held a Series 63 license, a Series 24 license, a Series 4 license, a Series 55 license, a Series 3 license. You are going to learn that after being involved in the trading on the New York Stock Exchange, Mr. DaCorta became involved in the trading of commodities, specifically currencies, and he started a business called the International Currency Traders, ICT, and that when he worked, he owned that business, and he once again was acting in a fiduciary capacity. He was trading individual clients' accounts in the currency market, trying to maximize profits and avoiding losses, and that when he did that, his clients each had individual segregated trading accounts. In 2008, there was a dramatic crash in our financial markets, and as a result, we had the biggest single-day drop in our markets, in the stock market and the commodities market, currency markets. And as a result of that 2008 market crash, there was massive job loss. And if you recall, the government, the United States big government, came in and bailed out some of the U.S. largest financial institutions, gave them millions of dollars to keep them from filing bankruptcy. Well, Mr. DaCorta and ICT were not some giant, large financial operation, and he didn't get bailed out by big government. In fact, he suffered such significant personal and business losses that he filed for Chapter 7 bankruptcy. The government didn't bail him out, and his investors lost their money in the marketplace. And you are going to learn that his company had to go out of business. It couldn't survive. And as a result of that, Mr. DaCorta was distraught, he was frustrated, and he was upset that he had lost his clients' money during this 2008 market crash. And you're going to hear that the NFA, that's the agency that regulates individuals like him who are trading in the marketplace for individual clients, did an audit. And Mr. DaCorta, bankrupt and broke, decided to give up on the marketplace, just gave up his license with the NFA. There was no findings of wrongdoing. He just didn't want to do it anymore. and he gave up his ability to trade as a fiduciary trader for individuals without reapplying for readmission to the NFA.
Why would defense counsel introduce so many irrelevant facts? They didn't apply to the trading his client did for Oasis and could only serve to confuse the jurors with useless information.
Mr. Allen should have explained that during the 2008 market crash, Mike's trading platform had reportedly been taken offline by his broker-dealer during a particularly volatile period in the markets. Taken offline, he was prevented from protecting his account. Consequently, it may be said that he wasn't responsible for funds taken out of his account when he had no control over it.
Without such a clarification, all the foregoing irrelevant information provided to the jury was probably more prejudicial to Mr. DaCorta than beneficial to his defense.
Let's review what Mr. Allen said in this portion of his opening statement. A company can satisfy its debts and not be profitable. He thus distinguished revenue from profits. Equity financing involves selling shares of a company. Investors own part of the company and profits and losses are shared with them. Debt financing raises capital by borrowing from lenders. Profits and losses are not shared with lenders. Debt-financed funds are used for purposes stated in a promissory note signed by lenders. Oasis used both equity and debt financing to fund operations. The only obligation Oasis had to its lenders was to meet the terms of their promissory note. A fiduciary trader trades for individual investors, whereas a proprietary trader trades for his company. All Oasis trading was proprietary, meaning it was done on behalf of Oasis, not for individuals. Spread is the difference between the buy and sell price in a currency exchange. Mike DaCorta surrendered his membership in the NFA and could not renew it.